Such a pleasure to be with you right here on the India Development Debate on ET Now. I'm Supriya, Shrinate, and with me is Sandeep Gurumurthi. It really is a huge setback for Cyrus Mistry, who's locked in a prolonged legal battle against the Tatas. In a landmark verdict, the National Company Law Tribunal has rejected all his charges against the Tata Group, including the petition challenging his unceremonious removal as the chairman of Tata Sons. Now, NCLT has found no merit in the accusation of mismanagement and oppression of minority shareholders' rights. In a big morale boost for Ratan Tata, the tribunal also said there was no evidence of the Tata Group doyen acting as a shadow director of the holding company.
Now, this is surely not the end of the road for the Mistry camp, which is likely to file an appeal against the NCLT ruling, but it is a big victory for the Tatas, especially Ratan Tata, who stands vindicated now. The clean sheet from NCLT is also an endorsement of the Tata way of doing business. While India Inc.'s top CEOs have welcomed the verdict, there are at least a few who believe some of the charges raised by Mistry on corporate governance are serious. On our flagship show, the India Development Debate, we put to test the NCLT verdict in the Tata-Mistry battles and what it means to India Inc. at large. Joining us on this special edition of the India Development Debate, Gopal Jain, Senior Advocate, Supreme Court; Sriram Subramaniam, Founder and Managing Director of InGovern Research Services; Jain Gupta, Founder and MD of SES and former ED SEBI; and Suhail Seth, Managing Partner, Counsel Age India and a friend of Ratan Tata, joining us from Moscow. Thank you all so much for joining us on this leg of the India Development Debate. Suhail, let me start off with you. Is this a big vindication for the Tatas?
As you rightly said, Sandeep, in your opening remarks, it is not just a vindication, it's a reiteration of the values, the methodology of doing business at the House of Tata, and most importantly, the scurrilous allegations that were made against Mr. Tata, his fellow director in the trust, Mr. Soonawala, and more recently against his colleagues. To my mind, what has happened is four things. Number one, the court verdict, as you very rightly know, has said that there was no power that could stop the board of directors from removing Cyrus Mistry. Number two, his removal was because of acrimonious behavior, which included leaking company documents. Number three, there was no evidence, as you said yourself, of any prejudicial conduct on the part of Ratan Tata. And number four, please understand that Cyrus, for whatever reason, has followed a scorched earth policy. You cannot make the courtrooms your playground just because you have a point to prove. You know, Supriya used the word unceremonious exit. It wasn't whether it was ceremonial or unceremonial. What had happened was that the board had lost confidence in one of its members, who at that time happened to be the chairman. The chairman, till the afternoon, October 24, 2016, saw no reason to either suspect, allege, or cast a slur on the reputation and the behavioral pattern of the House of Tata. But suddenly, after 1:15 p.m. on October 24, 2016, in his light, a man who had occupied the chair of chairman of Tata Sons, everything that the Tatas did began to seem wrong.
Right.
In hindsight is a very good place to be in, provided you are credible and ethical.
Absolutely. In hindsight, they also say it's 2020. If there was one man who I knew will be in Moscow for the FIFA World Cup, it's going to be Suhail Seth. I'm hoping you're having a great time there, Suhail. But I'll take this across to Gopal Jain. And Gopal, will this order in many ways remove the stigma on the Tata Group over their governance practices? You know, when those charges were leveled, there was this shroud of stigma that did come around. Do you believe this order effectively removes that?
Yes, completely. And like Suhail said, we have to see this in context that long before open governance was a buzzword, the Tata way of doing business or management always had inbuilt open governance built in it, robust systems in place, which is why they were known as a very credible house. And when you look at the ruling today, it's a vindication and a reiteration of that. And as you said, removing any stigmas or strictures which may have come to be when a case was filed. But even more important, that the court has emphatically said that the allegations which were made were completely unfounded and baseless. So far from clearing, they have also said the accuser or the informant or the complainant or the person who approaches the court, he himself had other motives to do so. So it's sometimes, It's like a brahmastra. You set it out to kill somebody, it comes back to kill you or haunt you. This seems to be a hit wicket case where it has come back to haunt them for even having made these allegations. And 3, I think decision making process of an expert body, this is a good example of that, reiterating the powers of the board of directors, reiterating the fact that the articles are most important. They have segregated the grain from the chaff, allegations misplaced, unfounded, baseless, but they have reiterated the correct legal position, which I think is very important, because the NCLT has a very important role to play as part of the 2013 amendment to the Companies Act, and also on corporate governance issues.
Absolutely.
So this is a landmark judgment from that point of view.
Okay, you're calling it a landmark judgment, and Suhail says it's a win for the Tata way of doing business. But let me get in another view. Sriram Subramaniam, in some sense, and there are critics who believe that this order is a setback for minority shareholder rights, given the fact that it was a high-profile test case. If a very significant minority shareholder like the Mistry family is unable to extract their rights, then what about scores of minority shareholders? So how are you reading this judgment of the NCLT?
Unlike, one cannot read this as black or white. I mean, one has to get into the specifics of the allegations, and the specifics relate to oppression and mismanagement. And there are specific instances that Mr. Cyrus Mistry, as the largest minority shareholder, has put out. Of course, he may not be right on all counts of the allegations, but there may be merits to some of his allegations. For example, he has talked about the nano project, and in June of this year, the Tatas have produced one nano car, which for all this one says that the project is a failure, but yet the company is not shuttering it down. 2, the company's Tata Sons has converted itself into a private limited company from a public limited company and restricted some of the rights of minority investors in Tata Sons itself. So that means that Cyrus Mistry and his family's shareholdings get restricted to some extent, and that is his countenance. So yes, there are many pleas that are there in his case, one of them being his unfair removal, but maybe the NCLT is right there by saying that the board has a right to dismiss any of its members having lost confidence. That may be true, but on the other hand, these instances of oppression of the minority shareholder, and if you view Cyrus Mistry as a minority shareholder, definitely some of these relate to his aggrievement. And I can tell you that this sets a precedence in some ways of how oppression and mismanagement cases will be handled in future by courts. And unfortunately, the competence of the board cannot be judged purely based on the names in the board.
Fair point. Okay, just hold your thoughts there, because I want to quickly take this across to Mr. Gupta. But Mr. Gupta, just before I come to, I will take a quick question with Gopal Jain and then come back to you. And Gopal, has the NCLT made it clear once and for all that the board of directors of a company is within its rights to sack a chairman if they think so? And if that is indeed the case, what implications could this judgment really have?
So two things. I haven't had the benefit of reading the judgment, so we have to go on the basis of what has been reported. As I said earlier, they have obviously reiterated from what all of you have said, the powers of the board to be able to sack its chairman. That is always conferred both by law and under the articles. So therefore, to that extent, yes, it settles the position, subject to, of course, any further challenge which would be. And they've also then in this case applied it. So it's not just a question of recognition of the power, but also they've applied it and upheld the decision of the board to sack the chairperson. So it sends out a good signal, but like I said, we'll have to see the reasoning and read the judgment to have a more elaborate discussion on it.
Mr. Gupta, let me bring you in. The issue perhaps was not so much about whether the board has a right to sack its chairman, but whether the Tata board followed due process and offered cause while showing Mistry the door. Now, Cyrus Mistry has claimed and maintained that he was told about his ouster just 15 or just a few minutes before the board meeting. He was not given the 15 days notice that he's entitled to. Do you think these issues have been taken into cognizance by the NCLT?
See, first of all, as I would say, Mr. Gopal Jain was saying that we do not have the benefit of reading the judgment. So, all our opinion is based on what we have been hearing on the TV and reading on the internet. I would first say that the starting point was that there is an operation of minority, and under that he said that he has been removed as a chairman unceremoniously or whatever you may say. Now, the court, the NCLT has held that the board of directors have a power of removing the member, and I would say that none of the power can be absolute. All these powers cannot be unfettered power, but yet as long as there is no mala fide, the law is followed, then there is no problem. Now, there has been a case made out that since the selection was through a committee, through advertisement and something, the same process should be followed. I do not agree, because when you select a person, you select out of n number of applicants, you see who is the best. But once you have selected the person, you find that he is not fitting the role, then you do not go through the process and remove him. You got to remove him immediately, because you feel that the much more damage can be caused. Now, the question that has been raised, and I would beg to differ with my friend, good friend Shriram, that operation of minority, I would have understood operation of minority in case Mr. Cyrus Mistry was not on the board. Mr. Cyrus Mistry was on the board for 3 or 4 years, and he was party to each and every decision, whether it is a majority decision, minority decision, but he was a party to those decisions. Now, suddenly when you are out of the board, you cannot raise fingers on each and everything. That shows very clearly the character of Mr. Cyrus Mistry, that while I am there, I am happy with you guys. The moment you are removing me out of your company, I am all the time criticizing you. So, that is the major issue. The operation happens when I was helpless, but I was chairman of the board. I was sitting on many companies. Now, if I am questioning decisions of those companies, I do not think I am absolutely right in that thing. The other issue is this, that Shriram raised the issue of the Tata Sons being made private. Tata Sons has always been private. It was a deemed public company. And when the law changed, it has changed.
True, true. Yes. Mr. Gupta, you've got a point there that till you were the chairman, everything was all right, and once you decide to get out, you start throwing these allegations. But Suhail, I'll come to you, and I think the other grave charge and a very serious charge was on flow of stock-sensitive information between operating group companies and Tata Trust. Are we to assume here that there has been no exchange of privileged information to trustees, including Ratan Tata, or has the information exchange really happened within a Lakshman Rekha, and so it doesn't really matter?
See, you know, none of us, neither you nor me, are sitting there to know, but I can tell you from the character and the way Ratan Tata runs businesses, the way the Tata Trusts have always run businesses. The trusts have been in existence for 125 years, Tata Sons for 150 years. It didn't happen. A. B. I brought out the point that until October 24, 2016, Tata Sons, Bombay House and Tata Trust were 3 plants in the Garden of Eden. Suddenly, when Cyrus Mistry is removed, that Garden of Eden turns into a Garden of Despair. So obviously, there's a lot being said which is completely unfounded and untrue. Number 3, you've had the finest legal counsels on either side, on Cyrus's side, on the Tata side. I'm sure those wise men have enough intelligence, enough gall and courage to bring out these issues of mala fide or malpractice or allegations, as you've mentioned, about insider trading. The fact that you can't prove anything. See, in our country, it's very easy to say, oh, that guy's a thief. And it'll stick because we're a great nation for sensationalism. The reality is no one wants to go into evidentiary details. These courts have gone into evidentiary details. The court case didn't begin yesterday. It's been going on since the 26th of October. If you remember, he sent an 8-page email to all and sundry. Now, you don't send an 8-page email with data points obviously, unless you've collected it, and there's a pattern where I completely agree with Gupta ji of SEBI. It wasn't that he suddenly woke up, or Mr. Tata suddenly woke up, or the directors suddenly woke up and found Cyrus to be unfit.
Sure.
There's a pattern of behavior.
Sure.
This pattern of behavior has been questioned, in a court of law against the prism of allegations. Those allegations today have found to be unfounded yet again. This is not the first time the NCLT has ruled in this manner, but on all these points of law, yes, it's a composite ruling.
Okay, I take that point.
My point simply is that, you cannot make courtrooms your personal battlegrounds because you have a point to prove. Yes, everyone is entitled to justice.
Sure.
But there has to be some level of calling, because you're making a mockery of the justice.
Okay, I take that point, Suhail, but since you spoke about charges sticking, the one charge that has stuck is in the case of the Air Asia issue. And let me come to Sriram Subramaniam. In the case of the Air Asia, the ED and CBI are both investigating into these are alleged payoffs that Mistry had flagged off in 2016. The managing trustee of Tata Trusts, his role has come under scanner. He's been summoned by the CBI. In this backdrop, would you say that this sort of, clean sheet is coming too early and it's too early for the Tata Group to celebrate? How are you reading that in the context of the action that the CBI and other investigating agencies are taking with regards to the Air Asia case? Mr. Subramaniam.
Yeah, I mean, that's one specific instance. But we cannot paint people as good or bad, right? I mean, even the best people have their weaknesses and the worst people have their good qualities. So at the end of the day, all I'm saying is that the same board, of Tata Sons, with all its luminaries, in its performance appraisal just a few months before October 24th, ruled that Cyrus Mistry was doing great, and there was no remark at all, no negative remark. And how did matters change within a matter of months then? And many of these issues had festered. Air Asia is just one point in case. There is also the other issue of Ratan Tata's personal relationships with Siva Sankaran, who is now in default of many banks, and the Tata Telecom venture itself has gone into doldrums. So all these other issues are what has been pointed out as mismanagement. So yes, the courts have now ruled that some of these are operating decisions. That is fine. Two is obviously the entire chain of command, the terms of reference between the operating companies and the holding company and the shareholders of the holding company is not yet clearly defined. In fact, immediately after October 24th, the Tata Group came out and said that we will define a clear and straightforward operating terms of reference with the operating companies, and that hasn't come out even till date. I mean, that is almost a year and a half or more now. And so the governance structure hasn't changed dramatically since what was there on October 24th. And so from that perspective, I don't view people as either black or white. I mean, there are various shades of gray. People have their weaknesses, and Ratan Tata or whoever it be have their weaknesses. And some of these are shown in some of these cases like Air Asia. All
right, I'll just have to come in there. And Gopal Jain, I think being a lawyer, you're perhaps best placed to answer this question. Is this going to be a long haul? Despite a big blow from NCLT, the Mistry camp is preparing to move the appellate tribunal. This case will perhaps be settled only by the Supreme Court. Is that a fair assumption to make here?
Yeah, this is like an inevitable journey which happens in cases of this kind, that it has to go all the way up to the apex court, because they always have the last word in the constitutional scheme, and everyone wants the issue to be finally decided in their favor. So if you lose, you challenge. If you lose the challenge, you decide to go to the Supreme Court, and certainly this raises important questions otherwise also. So yeah, you're right, that's a fair assumption to make, that may be the end journey of this case. But the fact that the tribunal at the moment has ruled decisively on these issues at least means for the moment the issues have been settled by the first court, which is the NCLT.
Absolutely, and that is an important point to note here. Mr. Gupta, while the NCLT may have found nothing amiss as per the current Companies Act, specifically with regard to Section 244, but is there a case now for another overhaul of the Companies Act to plug in some of the issues that have now come to the fore in light of this particular case?
See, I would really not know which are the issues you are talking. The Company Act is only 4-year-old now, and you are asking for an overhaul. The Companies Act took about 50 or other 60 years to change. So, I do not think there will be any overhaul. If there are any issues, that will be taken care. But I would come to few issues which have been discussed. Somebody has been talking about the insider trading. I do not think there is any insider trading issue, because insider trading, you got to do trade. Now, if somebody has traded based on insider trading, it is going to be an issue, but as of now nobody knows whether there is a trade or not. The second issue, you asked a question to Sriram about what happened to the CBI inquiry on the Air Asia and all other case. Now, please remember, this was a civil case which only decided a point of law on operation of minority and other issue. It never went to the case of corruption or case of impropriety or all other cases the CBI is looking. So, that is a parallel issue. So, it will neither be influenced adversely or positively by this judgment. That is one. The second issue is very clearly that, again it says that how Mr. Mistry was removed in a day, he was very good till 10 days back. Now, I do not know whether it will be right to say or not, but I would say that before Nirav Modi episode came, Nirav Modi was your poster boy. So you do not know what happens tomorrow.
Yeah,
you have found somebody good today, but he may not be good tomorrow. So you can't take precedence of past behavior as a future guarantee.
Right. Mr. Gupta, but just to take that point forward, and Suhail, I think you were the best place to answer this question on Ratan Tata. What does this personally mean for Mr. Tata himself? I mean, even an adverse comment by NCLT would have cast a shadow on the House of Tatas, and here, you know, it's a body blow for Cyrus Mistry. It's a big advantage for the Tata House and the Tata Group. But personally for Mr. Tata himself, I think you'll be the best place to answer this.
You know, both Ratan Tata and his EA Venkat, and people talked about AirAsia, and Sandeep used the right phraseology, saying that it is alleged. Let me tell you about Ratan Tata very briefly. The man is impeccable in terms of integrity and ethics. When you inside know who you are, you don't need the world to judge you. You know, mere mortals are the ones who worry about Judgment Day. And, you know, Gupta ji rightly said, a guy can be damn good until last night, but he can change. I mean, you're a 24-hour news channel. You know about change more than anyone else does. So Ratan Tata, for him, it's not about, oh, is it a big victory? Is it something you're delighted about? It's a quiet re-establishment, reiteration, and vindication of the way of life at the House of Tata and the way he runs his life. That is more than enough. Nothing else. You know, it's not about being platitudinal and grandiose statements. He's gone way above that, and he's always been that. You remember he said during the time of Singur, he says, I believe that if I've done the right thing, I will stand there. You have a gun. You either shoot or move out. I will not move. So he won't waver. And I'm glad that a man who's done so much, not only for the House of Tata, for Tata Trust, which in turn has done for every Indian who they are privileged to serve. So we should all owe sense. You see, it's very easy in our country to knock everyone down, to knock everything down.
I take that point. Suhail,
we'll have no one left, my friend Sandeep. We'll have no one left but you and I in television studios.
I take that point. I take that point, Suhail, and you know, quiet vindication perhaps sums it up well. Sriram, let you have the last word and a broader picture beyond the Tatas, beyond the Mistry. India Inc.'s sort of poor governance standards has been under the scanner for a while now. You know, we've seen other high-profile cases as well, you know, over the last 12 months. The ICICI one that comes top of mind. Will today's order help reclaim credibility of corporate India and restore confidence in the eyes of foreign investors? Because incidents like this damage the perception of Indian business in the eyes of foreign investors. Will this order, in some sense, restore credibility to corporate India?
No, in fact, incidents like this, what happened with the Tata Group and at Infosys and at ICSI, are the ones which enhance credibility to extent, because the fact is that no longer is anything up for just this one. We have to look into the merits of each and every case, and these are the issues which are coming out. And as corporate India moves from more of family owned and run companies to a professionally run setup, I think more shareholder activism and more of these cases will come out. And even now, for that matter, even with the Tata Sons, what is the succession plan is not clear. And so I think that transition will continue to play out even with the Tata Group and in other Indian companies too.
Oh yes, in some sense it is a sign of coming of age of corporate India. On that note, completely timed out, so I'll say Sriram Subramaniam, Jain Gupta and Gopal Jain. Appreciate you joining us with your perspective on this first leg of the India development debate. It's quite vindication for Ratan Tata, but the battle is perhaps not over just yet. Supriya?
Indeed, and on that note, timed out here on the first edition of the India development debate, but we will be back with an all-new edition and an all-new topic, which will be about the world's largest manufacturing facility of smartphones. It's going to be all here in India. Samsung, how big a deal this is? Will others follow queue? And what happens next?